We have a VA session and VA speakers today. I just introduce our Sangat with them. Mr. Umesh Parikh is a senior partner and founding member of firm having a diverse experience in corporate and legal practices and providing advisory services to various listed and unlisted company from more than 35 years. And Mr. Uday Dave. He is co-founder and partner at Parikh Dave and Associates, a leading practicing company secretary firm of Ahmedabad, Gujarat. Thank you, Mr. Dave, and thank you, Mr. Parikh, for joining us today. And I request you to kindly provide us the insights for partnership firm and LLP and companies.
Myself, Uday Dave, and me, it's my senior partner, Mr. Umesh Parikh.
Hi,
And
good morning,
sir.
everybody. I'm Umesh Parikh.
So what we are proposing is that we will run through a small slideshow discussing various aspects of a business entity. So to begin with, as everyone knows, a sole proprietorship is a business that you want to run once you want to start everything on your own from your small office or your from your residence. It's a small kind of business, maybe mostly trading, very small level of manufacturing that is accommodated under a sole proprietor. When two people come together, so then the question of partnership firm, arises. So this is the partnership firm which enables two or more persons to own an organization, and they agree to share the profits and losses of the organization. What is a company? So company is established and registered under Companies Act. So it's a legal entity established by a group of individuals or entities engaged in business, commercial, or industrial enterprises. A company is an artificial person and also known as corporate person. And it can own properties in its own name. It can have liabilities in its own name. And it is generally to make a profit from business activities. But you may have also seen, clubs like Karnavati Club, Rajpath Club, Sports Club. They are Section 8, Section 25 companies, which are, not for profit organizations. Then the third form is what is a limited liability partnership. It's a modified version of a partnership firm where, the liabilities of the partners are limited to an extent as stated in the LLP agreement. So suppose people from two different vocations, they want to come together. So just taking example of two doctors. So one is the heart specialist and the other guy is, say, orthopedic doctor, and they want to start a business right together. Then they can limit their liabilities relating to the field that each of them is taking care of. So all the heart related liabilities can be attributed to the heart surgeon, whereas all the orthopedic related liabilities can be attributable to the orthopedic surgeon. So there's a flexibility, and basically it is for small and medium enterprises and more suitable to the professionals. Now let's come to the point. What is the difference between a partnership firm, LLP, and a company? So it's a small comparison that we have prepared. So Governing Act for Partnership Firm was enacted in 1932, and unfortunately for more than it's 90 years now. So government is thinking on serious lines to amend this Partnership Act, and hopefully we may soon the new act very soon. So far as private limited company is concerned, the private limited company is governed by Companies Act, whereas LLP is governed by Limited Liability Partnership Act. Fortunately, LLP Act and Companies Act have been revised or introduced in recent past, so they are more relatable to the practical reality of today's world. For partnership firm, registration is optional. For LLP and company, it's a mandatory. So once the company is or LLP is registered, then it can start working. Whereas for a partnership firm, that's completely optional on the partners. The governing authorities for partnership firm is a registrar of firms, which is a local authority and falls under the state governments. Whereas for LLP and company, it's a register of companies, that is Ministry of Corporate Affairs, and falls under the central government. So you may see different regulations for partnership firms, different from state to state. As I've said, that it is falling under the state domain. Legal status for a partnership firm, it's not a separate legal entity, whereas LLP and company both are a separate legal entity. We'll come back to this point of separate legal entity for benefit of all. Point number 5 is name of the entity. So it starts with this for a partnership firm or even for a sole proprietor. The promoters are at liberty to have the name whatever they want to, and they need not obtain any prior approval from any of the authorities. It's for you to just decide a name, get yourself registered, and you can start the business. Whereas for an LLP or a company, prior approval of the Ministry of Corporate Affairs, we'll call it MCA in short, is required. So once the application for availability of name has to be made, and once that name is made available, thereafter LLP or company is formed, and once it is formed, it can start its business. So there's a small compliance that needs to be done before the name of LLP or company is finalized. Here, the promoters need to be more careful about not only the names, but trademarks also, because in recent past, ministry has realized that people have been misusing the companies to trespass the registered trademarks. So while reviewing the name, MCA reviews the names of all the existing companies, LLPs, and the trademarks. So after considering all three aspects, they will approve or reject the name. Point number 6 is a member's liability. In case of sole proprietor as well as partnership firm, the liability is unlimited, and it can go up to the shirt that the partner is wearing as on the date. So that is a part which needs to be considered seriously. So far as LLP and companies are concerned, the liability of each of the partners is limited to the amount that they have paid. So in case the company makes a huge loss, as a shareholder, you don't need to pay anything extra. So far as directors are concerned, they can be held liable for some fraud or the activities which they have done in contravention of the act. But so far as members are concerned, their liability is completely limited. For partnership firm, the charter document is the partnership deed, whereas for LLP, it's the LLP agreement, and for company, it's memorandum and articles of association. So these are the charter documents. The name itself suggests that these documents are very important. Once when you start the business, it may seem that सभी लोग ये कर रहे हैं, अपने भी कर लेते हैं, फॉर्मेट आ गया है, साइन करके दे देते हैं. Please don't do that. Read and understand the contents of the deed or agreement, whatever it is. Discuss it with the people whom you trust. Just try to understand how it will work when some issue will arise in future. So it is really important to go through this deed and agreement well in advance. So far as company is concerned, its articles of association basically governs the relations between the members inter se. So that is the agreement between the members. So while incorporating a company with your partner, with your business partner or the third parties, we recommend that the articles of associations are read well, understood well, discussed well with your partners also, so as to avoid any kind of disputes or misunderstandings at a later date. Point number 8 is perpetual succession. As soon as the partners are no more, the partnership firm cease to exist. However, the legal heirs of the partners may be allowed to enter into a partnership firm, but it has no perpetual succession. Whereas the limited liability partnership and the company has perpetual succession, since they are born by the act of law. So their death has to be by way of act of the law only. Point number 9 is management. Partnership firm is managed by its partners. The LLPs are managed by its designated partners. So in LLP, there are two kind of partners. One is the partner and the second is designated partner. Designated partners are the people who are entrusted with additional liabilities of the management of the LLP, whereas the partners are simply financial partners, dormant partners, the way we call it. And the company is managed by its board of directors, and members have no say in day-to-day management of the company. Ownership of the assets of the company is with the partners, and partners jointly own the assets. Whereas in case of LLP and a private limited company, the company and LLP has to own the assets in its own name. So the owner is LLP or a company and not its members or the directors. Contract with partners or directors. Partners are free to enter into contract with anyone, with any of the parties for whatever amount that is suitable to them. In case of LLP, it's similar to partnership firm. So partners are free to enter into any contract. And unless it is specifically restricted under the LLP agreement, they are free to do it. And that's why I say that, it's very important to review the LLP agreement before it is signed and executed. The contracts with the director are governed by the Companies Act, and more or less there are no restrictions. Of course, there are certain disclosure requirements, but the transactions are not, they are generally allowed. Identification number is basically then a specific identity number is allotted to the individual who wants to be a director of the company or who wants to be a designated partner of the company, which is under Companies Act. And it is called as DIN, that is Director Identification Number. Which is granted based on the few documents issued by other authorities like passport authorities and the Aadhaar authorities. So that has to be submitted to obtain the DIN. A DIN is one-time exercise and valid for the life. That is not required in case of a partnership firm. Minimum number and maximum number of partners, if we see in a partnership firm, the minimum numbers is 2. For a limited liability partnership, it is 2. And for a company, in case of a private company, there has to be 2 members, or in case of a public limited company, there has to be at least 7 members. Maximum partners can be 20. For a LLP, there's no limit. There can be n number of designated partner in an LLP. Whereas in case of a private company, 200 members is the maximum cap. So far as a public company, there's no limit in case of the public company. Partnership firm, no share certificate is required. Only the partnership agreement is the ownership proof. So is the case with LLP. Whereas in case of a company, the ownership proof is the share certificate, which is issued by the company once the payment is made by the member. Transferability of the ownership. Partnership firms interest is generally non-transferable unless approved by the other partners. And again, it is governed by the partnership agreement. Whereas in limited liability partnership, there are specific regulations which are in the LLP Act as well as can be included in the LLP agreement that will regulate the transferability of the ownership. In case of a company, ownership is easily transferable, but as I've said that one needs to go through the articles of association, that how the transfer has been allowed or made permissible. In case of partnership firm, NRI or foreign nationals cannot be a partner in any of the Indian partnership firms without prior approval of RBI. So if one of your friends who is based out of India and having a foreign nationality, he cannot be a simple partner, a financial partner in your partnership firm. Whereas in case of LLP or a company, a foreign ownership is allowed subject to FEMA compliances. And in most of the cases, the government has made it very easy, and that falls under automatic route. When I say automatic route is no meaning that no prior approval is required. Only once the transaction is done, you have to intimate RBI within 30 days that we have issued these shares to 1, 2, 3 foreign nationals, and the job is done. Voting rights, as mentioned in the partnership deed. So which partner will have how much voting or sharing will be decided in the through the partnership deed. Whereas in case of LLP and company, LLP again, LLP is mostly on the same lines as the partnership firm, because it is a hybrid version of partnership firm and a company, where the attempt is made to ensure the limited liability of the partners. Whereas in case of a company, the voting rights are proportionate to the shareholding. So as many number of shares an individual holds, he has that percentage of shareholding and the voting right in the company. There are few cases where differential voting shares are permitted and allowed, but that is a very specific subject, so we can discuss that at some other time. Legal proceedings, so far as a partnership firm is concerned, we have seen that its registration is not mandatory. But if the partnership firm wants to sue someone or a third party, then it has to get itself first registered, then it can initiate the legal proceeding against the third party. Whereas in case of LLP and a company, it's a separate legal entity, so it can sue and can be sued in its own name without referring the names of the members of the company. Now comes the most practical part, that is audit of the accounts. So far as a partnership firm is concerned, that statutory audit is not mandatory, whereas tax audit is applicable as prescribed under the Income Tax Act. So is the case with limited liability partnership, that audit is applicable to LLP, where a turnover reaches to a cap of 40 lakh or the contribution, that is a partner's capital, is more than 25 lakh. Whereas tax audit is applicable beyond prescribed limit as stated in the Income Tax Act. In case of a company, unfortunately, audit is applicable to all the companies, irrespective of the size, so irrespective of the level of the businesses. So even if there's nil turnover, the company is required to go for audit and the tax audit. Annual filing is basically the annual reporting to the authority along with the financial data for that year. For a partnership firm, no return is required to be filed with the registrar of firms. It is only the income tax filing that is required to be done. Whereas in case of LLP, the annual return, that is in Form 11, and statement of accounts and solvency in Form 8 is required to be filed with the MCA. Irrespective of the size of business in that year, these forms are required to be filed. If the turnover is more than 100 crore, you have to file it. If the turnover is 0, still you have to file it. And once it is filed with MCA, it becomes a public document, meaning thereby that your data can be seen by anyone who pays the fees of 100 rupees on the MCA website. So that is one part. Whereas for a company, similarly, a financial statement in the form of AOC 4 and annual return in form of MGT 7 is required to be filed every year, irrespective of the size of the business. AOC4 basically contains your balance sheet, P&L and everything, whereas the annual return contains the details about the directors, the shareholders, and the affairs it has conducted during the year, as to how many board meetings have happened, how many shareholders meetings have happened. It contains those data. And again, this data is a public data. So there's a specific facility provided by the MCA where one can pay 100 rupees and get inspection of any company which is registered in India anywhere. And the entire data is available on the screen for 3 hours. For a partnership firm, there's no provision regarding holding of any statutory meetings. The partners may decide to meet at any time they want, and the same will be governed by the provisions of partnership agreement. Whereas the similar is the case with LLP. Whereas in case of a private limited company, 4 board meetings at least every year has to be held, and 1 shareholders meeting that usually you may be aware as annual general meeting, the AGM, is to be held every year. Maintenance of records. Partnership firm is required to maintain only books of accounts, whereas LLP is required to maintain books of accounts plus minutes of the meetings of the designated partner. In case of a company, the requirement is bit huge. So it requires to maintain books of accounts, statutory registers, minutes of the meetings of shareholders, and minutes of the meetings of the board of directors. Common seal is basically the signature of the entity. In partnership firm, there's no concept of a common seal. For LLP, it will be governed as per the provisions stated in the LLP agreement. And in the company, as mentioned in the articles of association, normally this common seal is asked by the bankers when the financial assistance is granted and the final documents are executed, like mortgage deed or hypothecation deed. So as a mark of acceptance by the company, the banks insist that the common seal is affixed on those documents. Admission as a partner and a member will be governed by the provisions of the partnership deed. So is the case with LLP. And for a company, by subscribing to the shares or purchasing shares of the company, either from the company itself or from somebody else. Cessation also will be governed by the partnership deed. Whereas in case of LLP, in absence of any specific provisions contained in the LLP agreement, that can be done with 30 days prior notice to the other partners. Whereas in case of a company, as we know, once you sell your shares, you cease to be a member of the company. So by selling those shares. Remuneration of managerial person, in case of LLP, has to be as per provisions of the income tax. Whereas in case of LLP and a company, the remuneration to the managerial person will be governed by the Companies Act, and usually there are no limits so far as a private limited company is concerned or LLP is concerned. Point number 28 is compromise arrangements. Mergers are not permissible in case of a partnership firm, whereas LLP can be merged with some other LLP, but it cannot merge itself with any private limited company or a limited company. So is the case with company, where a company can merge with some other company and not the LLP. So that cross merger is not permissible yet. So company can merge with some other company. Conversion. Conversion is basically getting the entity converted into some other format. So for a partnership firm, the firm can be converted into a LLP or a company as the partners may decide after following certain procedure. LLP can also be converted into a company. company can be converted into LLP. So conversion between LLP and company is allowed, but you cannot go back. You cannot convert yourself into a partnership firm. Point number 30 is operation and mismanagement. Once the disputes arise between the partners, it will be completely guided by the Partnership Act and the Partnership Agreement. And there's no remedy exists except the remedy with the civil laws, and the civil courts have the jurisdiction, which, as we all know, that take years and years to even come on the board. For limited liability partnership, again, it's a similar thing. So there is no specific provision contained in the LLP Act regarding redressal. So we need to include those provisions in the LLP agreement itself to avoid that kind of situation at a later date. For operation and mismanagement in a company, there are certain remedial provisions are there in the Companies Act, but the practicality part has to be seen depending upon the stakes involved of the person who is disputing and claiming operation and mismanagement. Dissolution of a partnership firm will be by way of mutual consent agreement or insolvency or certain contingencies, and in exceptional cases by the court orders. Whereas in case of LLP, it can be dissolved voluntarily by the order of Honorable National Company Law Tribunal, that we call it NCLT. So is the case with the companies. The company and LLP can also be wound up if there are no activities for more than 24 months. And if the company or LLP do not intend to carry out the business, it can approach the MCA, and MCA will close down the company or LLP, as the case may be. So that, as Madam CJ Walker has said, that don't sit down and wait for the opportunities to come. Get up and make them happen. Thank you so much. And I will hand over to Umesh, sir.
I think you must have clearly understood, and Uday has nicely presented the difference between different organizations. You see, whenever any person is starting a business, he would see 3 points, which is the tax efficient organization where he can legitimately save the tax payable to government. Secondly, when any disputes arises, which would be a better form of organization. And third is personal liability. You see, in case of partnership firm, the liability of partners is unlimited because it is not a separate legal entity. Partners are partnership firm. Partners are the owner of the partnership firm. So their liability is unlimited. If anything goes wrong, like if there is any GST liabilities comes, banks or any government statutory liability comes, then partners are personally liable. That is why it is called an unlimited liability. Whereas the new format LLP, which is a combination of private limited company as well as partnership firm, wherein the liability has been made limited. So in that case, partners or designated partners liability is limited. They will not be held personally liable. Whereas in case of partnership firm, if anything goes wrong, partnership, they personally liable to make good the liability. Whereas in case of LLP and private limited company, their liability only to the extent of their contribution or their share capital, which is they have contributed to the company. So this is the major difference. You might have seen in Ahmedabad also a lot of textile companies have been wound up, but their owners have remained same with full amount of money. Why? Because whatever they have invested in their textile mill has gone, but their personal liability has not been touched upon because it was a private limited or limited company. In this case, you have to be very careful because even in private limited as well as LLP, if you have given any personal guarantee to the banks, then it is a separate agreement between a bank and partners. In that case, they would become a personal liable. In other cases, they will not be held personally liable. Secondly, in case of LLP, you can have a, like in normal course, what happens, whatever you contribute towards capital, suppose if there are two partners having a 50-50% capital contribution, so in normal case, they will be sharing profit on 50-50% basis. But it is not so in case of LLP. You can contribute even lesser amount towards capital and you can be given more profit sharing ratio. Sometimes it happens if you are a technical like consultancy and you have a good employee, so you want to give a like profit sharing in that case, so you can have a like token amount towards contribution and can give a 10% profit sharing ratio also. So not necessary to have a in similar fashion the capital contribution and profit sharing ratio. The third thing is wherever, because in normal course, what happens, what chartered accountant or company secretary prepares the documents, agreements, and you just blindly sign it. So you have to be very, very careful to read each and every aspect of that agreement, because in case of any dispute, such agreements will prevail. You may not be knowing. Sometimes we have a lot of cases are coming in good faith. We are given in 5% shareholding in the company, and that 5% will become a headache for you in future because some good buyer has come to take over your entire company. Then during that period, that 5% shareholder may create a nuisance. He may not agree, him or you may agree with very higher prices, and the buyer who wants to buy will buy only 100% shareholding of the company. So in any case of such eventuality comes, you have to be very, very careful. So in case of LLP, whenever you are drafting the LLP agreement, you have to see that in majority cases, the decision is to be taken by majority of partners, means partners who are holding majority of contribution. Because sometimes we give a 5% shareholding, and if you have made agreement in such a fashion that unanimous approval is required, suppose to admit a new partner, then your 5% partner may prevent the admission of new partner if you have mentioned unanimous approval for admitting a partner in your LLP agreement. So such practical cases comes, we have to visualize it. In case of death, who will become a partner? What will be the valuation when there is a death of a major partner? Whether his legal heirs will get it or not get it. So such practical issues comes when there is a dispute or when there is an event arises. Third thing you have to see from taxation point of view, because the taxation is the main key issue, whether to keep a partnership from LLP or private limited company. In case of partnership and LLP, the tax liability is 30%, whereas in case of a company, it is at 25%. So there is an arbitrage of 5%. But the catch is like that, if you have a private limited company, how will you take out the money from that private limited company? Either by way of remuneration or by way of dividend. So again, when a private limited company distributes a dividend, they will have to, it will be taxable in the hands of recipient, like shareholder will have to pay a tax on that. Whereas in case of like LLP, there is a 30% flat shareholding, but whatever the profit share comes from LLP will be a tax-free in the hands of partner. So though there is a lower rate in private limited company, bringing out money from that private limited company appears to be difficult and will not be a like tax saving. So these are the major things we have to take care for choosing your organization or while converting your LLP into private limited company. I think hand over to Uday Dave.
We have, I think on the chat box, I can see a few questions are there. I think Mr. Sanjay Goyal has raised a question that can a proprietorship be converted into LLP by selling part shares? In case of sole proprietorship, that's a very practical and tricky situation, because in sole proprietor there is only one shareholder, that is the owner, whosoever the sole proprietor is. So far as LLP or a private limited is concerned, it is mandatory to have at least two individuals as the partners or members to form a company. So for sole proprietor, there is no need to have a separate permanent account number under Income Tax Act. But as soon as the nomenclature of the entities change from sole proprietor to a partnership firm, immediately the new PAN is required to be obtained. And once new PAN is obtained, all your GST registration and all the registration will get changed. And unfortunately, there is also not clear situation that whether you will get the continuity of the business or not. So if you are doing your business under sole proprietorship for say, for 15, 20 years, and the moment you convert it into a partnership, the history of your sole proprietorship comes into a question, because the partnership firm will be seen as a completely new entity.
Thank you, Uday sir. Thank you, Parikh sir. Now I invite all the members to kindly raise their hands in Zoom if they have any questions for Uday sir and Parikh sir. I think so. There is a raised hand from Unnati office.
I can have it.
I can have it, Rajaji.
I can have Uday sir. A great presentation. Sir, there is a question that what would be the procedure to transfer the certificates from in a private limited company, transfer a certificate from one person to another person, and the person from whom that certificate is to be transferred is no longer a part of the company. So what would be the procedure for transferring the certificate from an old person to a new person?
So the question is for a private limited company, right?
Yes, yes.
So let us take an example to clarify. Suppose in your company you have given some shares to Mr. A, and that Mr. A is no longer in contact with you or approachable by you. Maybe he has gone overseas or he has left the state and he is not in contact with you, right?
Yes.
And you want to transfer those shares which were given to A to your name or somebody else's name.
Yes.
Am I right?
Absolutely.
Yeah. So see, once the shares is given to any individual, so he becomes its absolute owner. So as Umesh sir has already said that you have to be very careful while issuing the shares to anyone. So don't issue the shares to somebody के नहीं, ये तो अपना दोस्त है, 2 महीने से जानते हैं, इसको शेयर्स दे देते हैं, नया आदमी कंपनी में लिया है, काम अच्छा कर रहा है, उसको थोड़ा शेयर्स दे देंगे, बढ़िया काम करेगा, उसको शेयर्स दे दो. No. So practically what happens कि शेयर उसके पास, शेयर सर्टिफिकेट उसके पास है अगर, और उसका नाम आपकी कंपनी में एज ए शेयर होल्डर है, तो उसकी कंसेंट के बगैर आप उसके शेयर्स ट्रांसफर नहीं कर सकते.
There is a procedure for transfer of shares under Companies Act because the company is governed by articles of association. So in most of the companies, there is a procedure which is prescribed under articles of association, how the shares of any company of that particular company is to be transferred. So in normal course, normally in case of private company, the shares are restricted. It's not freely transferable. See, if I am a shareholder of any private limited company, I cannot ask the company to transfer in the name of anybody, like any person. Normally, the shares are first when in case of private company, if any wants to transfer the shares, it should be offered to the existing shareholders. You cannot transfer the shares to any competitor also. So it is to be offered to the existing shareholders of the company at the predetermined valuation. If any existing shareholders of the company do not intend to buy the shares, then it can be offered to the outsider also. Even you cannot compel him to buy the shares. वो शेयर्स की कीमत आज की तारीख में 5,000 है, आप उनको 1,00,000 रुपया दोगे, तो इट इज हिज प्रेरोगेटिव वेदर टू ट्रांसफर और नॉट टू ट्रांसफर. यू कैनॉट कंपेल हिम टू ट्रांसफर द शेयर. ये मेरी वॉच है, इफ आई डू नॉट वांट टू सेल माय वॉच at any price, it is my prerogative. So shares is a movable assets of particular persons. So it is at his wishes whether to transfer or not to transfer. So there is a transfer. So in second case comes for transmission of the shares. If the shares are held by in your like grandfather and he passed away, and the shares are to be transmitted by operation of law. So whether there was a will is there, whether there is a succession certificate is there, according to that, the shares will be transmitted. Then it's a two different meaning. Transfer is a shares and transmission. Transmissions of shares means by operation of law. If company dies, then it will be transferred according to the will or succession certificate. In case of transfers is approved by the board of directors of the private limited company. There is a prescribed form where transferor signs, transferee signs. There is a witness, original share certificate with the transfer form will be laid before the board of directors of the company. Board approves it. After approval, on the back side of share certificate, company will endorse in the name of transferee. Transferor is signed, so the now become buyer will become a shareholder of the company. So his name will be entered in share certificates and it will be delivered to the buyer of the company.
Okay.
Secondly, I would suggest whenever you are holding the shares, you have to hold in joint names. As I said, if your grandfather has passed away, holding shares in single name, then all procedure is required for succession or will and everything. If the shares are held in joint names, suppose Mr. A and Mrs. A, if Mr. A passes away, there is only case of deletion of name in the share certificate. So on producing the death certificate, company will delete the name of Mr. A. Now shares will be held by Mrs. A. It's a very simple procedure and company is required to do this. So this is we have to be very careful when you are getting the share transferred. Initially, वो आपको बोलते हैं कि आपके single नाम पे कर दो, but you have to insist to have a shareholding in joint name. Similarly, whenever you are having a demat account, have a demat account in joint name and have a nominee. So, in case of any eventuality, nominee will take care, administer it, and very easily with very small process, the nominee will get entire shareholding in his or her name.
And just to add on a lighter note, that all these situations will be very unique. So whenever you come across anything like this, please approach us and we will try to find out some unique solution out of it. Right?
Thank you, sir. Thank you.
Thank you very much, sir. I can have a leader, Giriraj.
I can have a Ashok, sir. I can have a sir. Sir, Chacha, if you allow me, this is a digression. I would like, or it may be taken in another session by sirs. Okay, do you have any specific insight or input on MSME Acts, which is the present confusion over in the market?
Unfortunately, we are not the right people to discuss the MSME thing because that is not our domain. But as we have understood from our professional colleagues and friends, that recently there has been, under MSME Act, anyone who gets himself registered under that MSME is eligible to get the payment within 45 days from the date of invoicing or delivery of goods to the buyer of the goods. Unfortunately, the government has come out and practically till date the terms were like 60 days, 75 days, depending upon the different businesses. Government has recently introduced a provision where all the all the business entities are required to make payments of all SMEs in less than 45 days in order to ensure that the liquidity of funds is more in the business, as the business cycle will be more faster as compared to the 45 or 60 days business cycle. So that's why certain presentations have been made by Institute of Chartered Accountants of India to the Finance Minister to review the applicability and implementation of this. But beyond this, we won't be able to answer this.
Thank you, sir. Leader Kamalji.
My question is on borrowing. In private limited, apart from bank borrowing and directors, can we borrow money from individuals also?
Really good question. The thing is that in a private limited company, as the name suggests, that it's a private limited company. So a private company cannot borrow from a third person. Like, if you want to borrow from anyone appearing in on this Zoom call, you cannot do it simply because private companies are not allowed to borrow from third parties.
Limited company can borrow fund from directors and their relatives. So there are 8 relatives which are defined under private companies from whom they can borrow the fund. Private limited company can borrow from any other bodies corporate. Like if it can borrow from any another private limited company. Private limited company can borrow from banks and financial institutions. Apart from this, there is a procedure laid down under company that if they want to borrow from shareholders of the company. So then deposit, there are rules of deposit which are to be applied while borrowing from the shareholders for a limited purposes, and it cannot borrow from a person other than these entities. Like they cannot borrow from a person who is not a shareholder of the company. They cannot borrow from an individual or partnership firm because partnership firm is not a body for a company. So there are restrictions for borrowing by the private limited company. That is why, because once you incorporate a private limited company, so restriction starts, which is not so in case of LLP. LLP is free to borrow money from anybody. आप प्राइवेट कंपनी में कोई शराब के साथ बोरो नहीं कर सकते, शराब ही पैसे बोरो नहीं कर सकते हो. You cannot borrow from your friend also. So only direct relatives are permitted. Banks are permitted to borrow by private limited company.
Thank you, sir. Thank you, Kamalji ji. Sanjay sir, last question.
I have a question that can the share certificate of a private limited company be kept in demat form? Will a digital copy be valid in the court of law? Because, yeah.
Normally what happens that once the shares are held in demat form, it's not digital copy of the certificate. It will be your demat statement, which will reflect the name of the company. So that will serve the purpose.
No, but can I, because my private limited company is not listed company, na, so how can I demat?
So see, the thing is that demat is the additional facility where you can hold the shares in demat form. The way you can hold the shares in physical form, similarly, you can hold the shares in a demat form. And with 30th September 2024, government has made it mandatory for all the companies, private companies also, to have the shares in demat form. The companies who are not small companies, small company meaning thereby the company whose paid up capital is less than 4 crore and turnover is less than 40 crore. These companies are termed as small companies. They are not mandated, but beyond that, even all the private limited companies are mandated to convert the entire shareholding in demat form.
Oh, excellent. Okay. That is, the date is 30th September 2024?
24, yes.
Okay, thank you. That helps. Yes,
And
thank
you
you.
have your bank account wherein you keep a money like rupees. So there is not a digital. Similarly, demat account which reflects your entire holding. If you are a shareholder of any Reliance also, that will be reflected. You have to open your demat account with any depository wherein you can have your entire shareholding in demat form. You can also hold your private limited company shares in demat form. You can also hold in like Reliance shareholding or Asian Brown Beverage, whatever shareholding is in demat form.
नहीं सर, मेरा जैसे प्राइवेट लिमिटेड कंपनी है तो मैं अपने डीमेट अकाउंट में उसको कैसे ट्रांसफर करूंगा? द कंपनी हैज टू इनिशिएट द प्रोसेस ना.
See, there is a process. It's a two-way process. One is the process at the level of company. So the company needs to make an application for ISIN.
Okay.
That is International Security Identification Number. So application has to be made by the company through the agency called RTA, that is Registrar and Transfer Agent, with NSDL or CDSL. So tripartite agreement will be executed, and along with that, few documents are to be submitted. Based on that ISIN is allotted to the company. Once that ISIN is allotted, the shareholder needs to approach its DP or the demat account, where you hold the demat account. So they will give a demat request form. We call it DRF. So your original share certificate plus that DRF has to be given to your DP, right? And then that application will move forward, and then your physical shares will be cancelled and it will be converted into demat form.
Thank you. That helps.
Thank you very much, sir.
Excellent.
Leader Rohit, Leader Deepak, I request you to kindly send the questions in chat as we are constrict with the time. Thank you, Mr. Parikh. Thank you, Mr. Uday, for giving us so valuable time and so valuable information. I request Sham sir to please give a vote of thanks to Mr. Parikh and Mr. Uday.
Thank you, Umesh bhai. Thank you, Uday. I think मैंने जो मेरा अनुभव किया है बहुत सारे लोगों के साथ, स्पेशली स्मॉल सेक्टर में, ignorance makes them suffer a lot later on.
Yes,
और
sir.
वो हमने भी किए हैं और बहुत सारे लोगों को करते हुए भी देखा है. तो मुझे लगा कि आपके जैसे इंसान जो कि हमारी जैसी फिलॉसफी, गिव की फिलॉसफी से प्रेरणा लेते हैं, I thought we will request you and you accepted. Thank you very much. And it was wonderful session, and I think my learning got confirmed that what is happening and what should happen we should know, because size company की बड़ी हो जाती है और ठीक नहीं होता है तो बाद में बिल्डिंग कोलैप्स करती है. Thank you very much, and I appreciate it. Give a great. I can have it. Thank you,
Thank
sir,
you,
for
sir.
giving us this opportunity. And through you, we would like to convey कि अगर किसी को कोई भी query है, if you want to understand something, if you want to discuss something, और अगर आपको एक दूसरा session भी बाद में रखना है after some time to discuss the practical part, please feel open. Shyam sir is a great mentor. And he has because we interact a lot on a personal level also. So very special thanks to Shyam sir and everybody. Thank you so much.